You gave us a list of dates that you were at the VGM building, and
Yes,
then
that
you
is
meant,
correct.
were there any issues raised with you in relation to the performance assessment which preceded your removal, indicating to you any problems that would have resulted in your position in your removal?
No, at no point, at no point. It's just that if you look at the history of the NPA, particularly I think the minutes of the 24, as my colleague, Advocate Jiba, stated that I think it was a Q3 report that during that time it used to be normal that the performance would bottom down. So I think that used to be the problems across the spectrum because of Christmas, the holidays between December and January, as a consequence of which that will have a bearing, of course, that is negative on the ultimate percentage of the performance.
Thank you, Admiral Malacha. I've got no further questions.
Thank you.
Saldan. Thank you, Advocate Malacha.
Thank you so much.
Can I just ask one question of clarification, and it really relates to the set of last questions that you were asked. At the beginning of your testimony, you mentioned that, and you make reference to the meeting of 9th July 2012, and then you say at a point you were asked to step down, and then in 2015 I caved in. What do you mean by that?
So looking at the pressure that I was finding myself in, it always perambulated in my mind to just resign and join the bar. But there was a view that I thought at the time made sense, that if I resigned immediately after stepping down as the acting DBP, some people would have construed and transcribed that move as if I was running away. I messed up, then I'm running away. Hence, I had to stay. So in 2015, it's the year that I realized that anything and everything relating to the former acting NDPP Mloja had percolated. Then I thought it was a wise move to leave the institution. Then I joined the pupillage the next year, the following year, 2016.
So it's not, as, in a sense, caved into pressure or rumblings. It was just your decision that it's time for me to leave.
I must say, my relationship with my successor, it was, I wouldn't describe it as an icy one, but the treatment I was receiving, it was quite bad. For instance, if I go to court, I will be asked to provide report. I used to get good conviction rate in court. And then there will be remarks that possibly I'm choosy with the cases, I'm taking cases with no evidence. The remarks that took a steam out of me, and with discussions with the family and the relatives and some friends ended up saying, look, this is too much. You'll run out of sympathizers if you stay in an institution that is so toxic to you. Rather throw in a towel, hence my statement that it's the end of 2015 when I made a decisive move to cave in.
And that decision was partly motivated by the pressures that you were experiencing in the institution.
That was the position. That was the position.
One more question from me. You indicated that you felt the need to move away from the scene, okay, from the institution. And you say you somehow felt when the Boysen matter was taken away from you, you felt that it may just as well be you were relieved of the matter. But in fact, what actually happened in fact? Did you feel that, did you have a feeling that the matter was taken away from you? Or did you feel relief that you no longer have to deal with the matter?
Chairperson, probably I would not have come across clearly on that point. In relation to relief, I was saying when my colleague removed me from the position, that will be in 2012, the 9th, the position of acting as the DPP. I couldn't hold any grudge because the popular view was to the fact that you must thank her instead of holding anything negative towards her. You have been removed because of the pressure that was prevailing at the time.
Oh, that was, you said that about being removed from your position.
As the acting DPP.
Yes, yeah. But when the Boyson matter was given to another official to handle over your head, did you feel that the matter was taken away from you?
Chairperson, in respect of the Boyson matter, as the email has been presented in these proceedings, you'll realize that, and as I also explained the procedure in the office of the DPP, at no point did I physically deal with the matter. No advocates in my office deal in the matter. But one thing I realized though is that when they started talking about the Kato Manor case, and after casorily looking at the indictment, I could pick it up that some of those cases had been sent to the DPP's office, KwaZulu-Natal, for decision with consultation between the investigating officers in the matter and the advocates who would have been handling the docket in my office, agreed that prospects of success were non-existent, with the ultimate decision that those files are taken back to the lower court for prosecutors to do the necessary in terms of submitting the statements, affidavits, and documents for the courts to hold inquest. And it never ended there. Inquests were held, and then findings were made by magistrate of nobody to be held responsible. It's one of the reasons that galvanized me to be very loath to append my signature on the indictment, to ask for the report before I did do anything, a report which I ended up not receiving until my stepping down from the position.
But did you ever felt that your authority was being undermined?
Chairperson, I think you will see that coming out clearly in the email that I wrote to him, with the concluding remark that if I can be treated with dignity, this principal-pupil interaction that I felt at the time. I think that will be my concluding remark in the email that I sent after 9 o'clock on the 13th, where with cap in hand I was begging to be treated with dignity. The introduction refers to dignity, the last paragraph refers to dignity. That is the extent to which I felt violated. It was as if I was a terrorist. That's how I felt.
Thank you.
Thank you so much.
Ms. Power, you seem to want to communicate.
You were interviewed for the job of the National Director of Public Prosecutions not too long ago,
Yes, that is the position.
and you were asked a number of questions.
That is the position.
Would you confirm that what you had reported at that interview was true and correct?
Was?
That was not an interview that you had done under oath, correct?
That is the position.
But sitting here, would you confirm to this inquiry that what you had indicated in that interview to the best of your ability was true and correct?
That is the undertaking personally I took to give the best as I could.
Okay, thank you. I've got no question.
Thank you so much.
Thank you, Ms. Power. I think we are ready for cross-examination. Who's going to start?
I will, Madam Chair.
Okay. Mr. Masuku.
Thank you. Good morning, Advocate Mlocho.
Greetings, sir. How are you?
Very well, sir.
Yeah.
Can I just, I will have a few questions for you relating to the evidence you have given on the signing of the provisional delegation. You had a meeting before you signed that provisional delegation, you had been in a meeting where you were appraised of the reasons why your signature was necessary in that provisional delegation. Am
I
correct?
assume you're referring to the 29th of May
Yes,
meeting
yes, that's
between the
what-
three of us. Yes,
yes.
yes, I agree with you, sir.
So they at that time, even though you had reservations about the constitutionality of that, of the delegation, you accepted that there may well be a reasonable basis on which prosecutors from outside could be brought into your province, right?
Come again?
Well, perhaps because you haven't heard the question properly, let me just reformulate it. Can you describe to us what you understand by provisional delegation? What was it intended to do?
My understanding at the time was that the delegation will be provisional, pending the confirmation if that could be fine, and then it could be made permanent, because I was of the view that it was going to be a big project. If it was going to be taken to court, maybe it was going to take a long period of time.
Yes, but it related to you essentially provisionally delegating the authority to prosecutors outside your province, right?
Yes, sir.
So, in that meeting, did you feel that you were being pressured into signing that provisional delegation? Did you sense that you had to do it, otherwise the sky would fall?
Look, to tell you, the meeting was short, as I indicated. It took 5 to 10 minutes. And then two, I comprehended at the time that the matter was in my division. So when Advocate Chiwa suggested to me that, look, the opinion seems to suggest that both the delegation as well as the indictment, I did not put up any resistance to that suggestion.
Yes, no, I mean, you didn't put up the resistance because you did not regard this as undue pressure. You're not the kind of person who would succumb to undue pressure, are you?
You mean to be forced to sign the
Yes.
delegate? No, it was a discussion.
Yes. So,
Yes.
So what I'm saying to you, I'm not trying to catch you on anything. I mean, I think it's something that you've testified to. All I'm saying, I'm here. I'm a friendly force. If you want to know, all I'm saying is that in that meeting, you would say that it was a meeting conducted in a professional manner with due regard to the principles that underpin the workings of the NPA.
I will take it. I wouldn't take it professional, because as far as I understand, a professional meeting, there will be an indication timelessly, there will be a meeting, there will be items for the agenda, there will be an attendance register indicating who attended the meeting, and the item that would have been entertained at that meeting, if there are any resolutions, and the resolutions as well. So I'll have a concern if you use the word professional meeting, but I would say when I left that meeting knowing, one, she is my supervisor, I have to sign this thing. If she is right, I need to do it. If the law says I'm wrong, I was going to revert to her and say the law says I'm wrong. And then two, the indictment, I will sign it provided there is a memo or a report, an aspect that was not an issue when we left. We departed along those lines that I was going to sign these two.
I mean, you have a problem with my use of the word professional. Perhaps let me put it this way. That meeting was a meeting of professionals, 3 professionals, engaged in on professional issues.
For the record, yes, you are
Yes,
right.
thank you. You didn't have only one meeting with Advocate Chiva.
As I
You
indicated,
indicated a number of meetings, yeah.
as I indicated, firstly, she was appointed as a deputy NDPP. If I'm not mistaken, that would have been, I'm not sure whether after August 2011. So we used to spend quite a number of meetings together, and possibly even after meetings, we will intermingle together as colleagues. However, if my memory serves me well, her elevation into the acting NDPP's position would have been very late in the year 2011. But the first official meeting where I attended with her chairing, that will be the meeting of the 24th of January 2012.
Yes, but the question I'm really asking is that whatever position she held, you had a number of meetings that included.
You are correct.
Chiba,
You are
right?
correct. Yes.
In those meetings, would you say that Advocate Chiba placed conducted herself in any way other than a professional manner that and engaged in trying to resolve pertinent issues relating to the functioning of the NPA and the issues?
I'm not sure if I understand the question
You appear
correctly.
to understand it, because from your response, I think you do. But in case you don't, I will clarify.
Please clarify it for me.
So what I'm asking you is, in the meetings, all of them, the meetings that you can recall, some of them which you recorded in your black book, is there? Would you say that? Would you disagree with the statement that these meetings were conducted in a professional manner, and Advocate Chiba conducted herself in a manner that is consistent with how a person in a position should?
Let me give you an example. You will know that there is a presumption of multiplicity of perspectives. We all have our own perspectives.
I'm asking for yours.
At a personal level, she was good to me. She was fine. But professionally, I also have my own reservations. I will indicate to you why. For instance, if you look at the Amigos case, with the Amigos case, I just received a call from the PA. I think Palisa saying, please come to VGM. To me, that was not fine, because that was a major project. Everything has to be professionalized. In advance, we need to know when is the meeting, what we are going to talk about. To date, I've never seen the attendance register of that meeting. I've never seen the issues that we discussed at that meeting. The only thing I have are my notes, which may be correct, which may be right, but in the absence of a professionalized documentation of the meeting, you know, so those are the governance issues. As a person, that I will have those reservations that maybe we can do better.
Okay, but so of all the examples that you could come up with that would raise concerns about Advocate Chiba's professional or governance, sensitivity to governance issues, it is this one that you raised, the Amigos case, right?
Yes.
And your problem there is that you needed, you would have liked to be informed in advance.
Okay. I'll give you another example. I've got quite a number of them. I was trying to give you a helicopter view. If you are prepared me to give the numbers that would have generated and aroused a concern at a personal level, I'll give you those.
No, okay, it's fine, you can give me those later on, but I'm asking you about the one that you isolated from a number of them. I understood that you're not saying this is the only one, but your immediate response would have been to pick up a very glaring example of what you would have considered to be a black mark in your understanding of governance. It is that she asked her PA to call you to a meeting, and that meeting was not minuted, and that there was no advance notice of that meeting, and you had a problem with that. Okay. I mean, I'm happy for you to call others.
Say yes.
My profuse apology. Yes, sir.
Yeah, so I would want you to mention others, but I'm really not interested in the others. The one that I'm interested in is the one that you picked up from the others.
I understand, sir.
They may ask you others if they wish to, but I'm not going to ask you. The questions that were asked by the panel relating to overstepping the jurisdiction. So the two questions, one was overstepping jurisdiction, the other one was whether you had any reason to believe that you were being deliberately excluded from the cases, and your answer was that up to today you don't know why you were never given any reasons. Now, on the first one relating to overstepping the jurisdiction, you accept that when you signed the delegation, although you believed it was a provisional delegation, you're essentially inviting people, prosecutors from outside the province to come in. It's normal. It's not an unusual thing.
Already, the day preceding the 29th, I was aware that my colleague Advocate Chauge had called, giving me a call saying, look, I've got this instruction from the NDPP to dispatch a team of prosecutors. So I was aware.
Right.
Yes.
So I'm saying you're not suggesting that there is no practice within the NPA of prosecutors from another province being invited to come and do matters in another province.
That's not my answer. All I'm saying is that if it were to happen, there are values that are there in the NPA, among others, the issue of professionalism, the issue of transparency, the issue of communication. If one looks meticulously at the emails that we were exchanging, you will see that there was no professionalism there. I wouldn't have asked not to be treated like a pupil, being treated like a principal by the DPP of another division. And frustratingly, there are other senior officials in the NPA who are copied in the email. Did you see there is no response even from one? I was a lone ranger swimming against the sea.
Yes. So, but the question I'm asking you is a question of principle. You cannot say here and tell the panel that it is a practice, the practice of one prosecutor from one province performing prosecutorial functions in another is an unusual practice within the NPA.
I think I've answered in the sense that I say there are processes and procedures in place that ought to be followed.
So as a principle is there.
Yes, yes.
So if those processes are followed, there would be no problem with it.
Absolutely.
You just resent that in this particular case. You believe that they were not followed, right?
I don't believe they were not followed. It's this chain of events that happened, putting me in a position where I've got no other conclusion to draw except the adverse one.
Which is what?
That I was being frustrated in the process.
Sorry, what is it exactly that you say you're being frustrated about?
Say, firstly, I say we agree, all three of us, consensus at the dam, the indictment with the memo, and then there's an opinion from Gerald Nell, from Legal Affairs Division or Section. I knew that a guy like that existed. I trusted Advocate Chiba when she said that. I did not even bother her to say, favor me with the report. I accepted that. All of a sudden, that is why when you read my email, I say to my colleague, my eye popped out, my lower jaw dropped, shocked to the marrow of my bone, because for the very first time you're asking me about the report. I had raised the issue of report during the discussion in the office. I had raised the issue of I think I indicated there. So that was what was frustrating me.
Yeah. No, I understand. And in the big organization like an NPA, there will be those kind of moments when you feel that your colleagues are undermining you, and you've got to stand up and as you did in this email,
You're 100% right,
put
sir.
them into their place.
You're 100 right,
Yeah.
sir. 100%
But what, as you know, I mean, this inquiry really is about the fitness of Advocate Chiba. My interest that I want to draw from you has something to do with that. And that is why I'm asking you, when you talk about pressure, you have to bear in mind that what I'm seeking from you is for you to tell me what it is that you believe was the pressure that was put on you by Advocate Chiba, and describe what the nature of that pressure was, so that I understand what it is that we should draw from your evidence of pressure.
Look, if you go back to my evidence, I enunciated in my evidence that the word of pressure only cropped up during the discussion of a telephone conversation I had on my way to Boshafstein. After that, she never used any word of pressure
Okay.
in my interaction with her. And by the way, that will mean the two of us, that is me and Mr. Mokgoro, we would have spoken about this case only on 2 occasions. During that telephonic conversation and in her office on the 29th of May, 2012. That was the end of it. After that, we never discussed.
And
the
you would
matter.
say there was no pressure at all brought to bear by her at any time other than the mentioning of that on the phone call?
I wouldn't say, you see the email by Advocate Chauke to
yes.
me. He says, hey, look, don't delay. I have to go back and report to Chiba. I have to go back and report to Minister. Minister, he does not describe. There are minutes that have now been presented here. Minutes from purported to have been, because I haven't verified that, purported to have been authored by Mozing, in which minutes he says, Minister seems to be losing patience in the slowness with which the arrest is not taking place in the matter. So it's a cumulative effect of those events that may put one in a corner where one does not have any other conclusion to reach except the inescapable one that there was pressure.
Okay. Now, of course, my colleague Advocate Power did ask you about the pressure, and you didn't say exactly. You didn't say that there was political pressure. Am I putting that in your mouth? You haven't mentioned the word political pressure at all.
Politics? No. I've never mentioned.
And from
in
your
this proceeding.
response, I assume that I shouldn't even ask you about politics.
Though we have to be apolitical naturally, but
Yes.
we're human beings. We can't talk about politics.
Yes. No. In the context of this, I'd rather refrain from asking about politics. Yeah. But really the final question, rather it's a comment. You were referred to Monsing's affidavit, and the paragraph 7 was read to you. And this is the paragraph which deals with the fact that an IPID investigation had been triggered, which relates to the conduct of the police in the Katomana events. You're aware of that?
Yes, I saw it in
Yes.
the affidavit.
So when an acting National Director of Public Prosecution is approached by the IPID and they say, look, this is what we're investigating in your area, that could be some form of, that could trigger an immediate interest by the NDPP or the acting NDPP to understand what is going on in that area, right?
Yes, sir.
You would expect that.
I would expect that, but my expectation will have to be within the legislative framework.
Absolutely.
Legislative framework in the sense that in terms of the Constitution 179, as well as the NPA Act, it stipulates, it enunciates the powers, duties, and rights of each person appointed within the entity. Among those things, the NDPP would not have been bestowed upon those powers to institute the prosecution, as those powers reside with the prosecutor in the lower court, with the deputy DPP and the DPP.
Okay, and of course, I mean, you know.
And before you, if I may finish, and if you look at my personality, look at my performance, you look at the projects that I was handling in KZN, I was not against the prosecution of anybody in the decision. Everybody knew that if there is evidence, if the prosecutor came to me saying there is evidence, I will say to the prosecutor, as soon as you have ascertained yourself with evidence, it's your call, whether you throw a book or the entire library at the accused person, I will be happy with that. So I wouldn't have,
Sorry, can I just take a?
not a problem.
Okay, I mean, you appreciate that Advocate Chiba appointed a prosecution team. She was not doing the prosecution herself.
Yes, sir.
Okay. I mean, the last question arises from your very pleasant comments.
Can I understand that question? Advocate Juba appointed a prosecution team. Are you being specific to what's under discussion? Not
Yes.
generally.
No, it's specific to his jurisdiction. Yeah. It's the comments, the pleasant comments you made about Advocate Chiba. That you had generally a good relationship with her.
At a personal level, I still
Yes.
take her as a good sister of
Yes.
mine.
Maybe I shouldn't ask you this question because I risk you giving me an answer I don't like. So I would rather not, rather not ask you that question. But if anybody would say to you that there was a manipulation of prosecution services to advance political interests, would you associate that with anything that you know of Advocate Chiba?
Firstly, my response will be, the devil is in the detail. Give me the specifics. I can't just be generic.
Yes. That's the
It's
question
the
I would ask
specifics
myself.
that will help me.
No,
If there's one case where I'm confined and limited to give a comment and would have reason during my tenure as the official in the NPA, I will definitely give a fair comment on that.
No, I'm happy with that. I also am looking for detail around that allegation in relation to Chiba. So both you and I are in the dark about the detail. Yeah, those would be our cross-examination questions. Thank you very much.
Thank you so much, sir. Thank you so much.
Sinati.
Mr. Rib?
Thank
your
you, ma'am.
turn. Thank you,
Thank you.
Mr. Masuku.
Afternoon, sir.
Good afternoon, sir.
You arrived with two documents here today in respect of Advocate Mokgoro. The document, the internal memorandum of 9 January 2012, and the letter from Ravindra Manikal and Company.
That is correct, sir.
Why did you bring these documents here today?
Look, those are not the only documents I brought in today. You can see I brought a batch of documents in the event I'm being questioned.
Yes.
It's quite a number of emails that I exchanged while I was still in the NPA
With various people.
with various people. And as I was going through my book, I realized that at some point I had a problem with Boot Lawrence regarding the representation going directly to his office. We exchanged email, after which I was left with that ambivalence, which galvanized me to approach Vili and say, Vili, please help me out here. This is my interpretation. This is Lawrence's interpretation, which also culminated in him really raising it at the DPPs. Other than that, there is no explanation.
Yes. You don't know why that letter was written directly to Advocate Mokgoro from the attorneys?
To date, no explanation has been given to me why it happened.
You do know that Advocate Mokgoro was appointed as the head of the SCCU with effect from November 2011.
I know that very well, because in this book, immediately after his appointment, he gave me a call. He said, Mhlegas, I'm coming to your division. We had a meeting with him, I think, mid-December 2011, if I'm not mistaken. We had a discussion with him, his experiences in the NPA, and so on and so forth. Yes, I was quite aware of that.
So, I mean, even from that answer, it's clear that Advocate Mokgoro was never tried to exclude you from anything. He was, in fact, communicating with you.
Look, the feeling of exclusion would have struck me at the time when I saw him not directing the email even to me as the head of the division. Instead, directing the email or the internal memo to my subordinates, the head of the SCCU. So I felt like if you read the law report and there are footnotes, all of a sudden I'm head of the division, but I'm appearing there in the footnotes now. It's against that background that I transmitted an email to him saying, look, Mhlegas, 179 Constitution 22 seems to be giving more powers than you in terms of this. Because we did not agree, I had to get a second opinion and say, Vili, help me out here. And then Vili said, you seem to be on the right track, but let's share it at the meeting so that we can get the view of the other DPP. That is the long answer to your short question.
Yes. Could we have shorter answers possibly? You were copied in on the email. You weren't excluded. You didn't try and do something behind your back.
Yes.
And what Advocate Mokgoro will say, if required on this aspect, is that he believed that as in terms of the proclamation, he had the power to deal with serious commercial crimes, and that the representations had been made directly to him, and in that capacity he was dealing with it. He didn't exclude you at all from anything.
I'm not sure if I'm clear enough. The special director, commercial crime, Put Lawrence, yes, in terms of the proclamations, he was bestowed upon, or he is bestowed upon those powers. And the DPPs, in terms of the NPA Act, are bestowed upon those powers, among other things, to initiate the prosecution and issues incidental thereto. When does the problem arise? The problem arises in an instance where there is contradiction, where there is disagreement between the special director and the director, with the question perambulating in that direction as to which view must prevail should that situation arise. That is where we are. That is what was discussed at the meeting.
But I'm talking about you. I'm not worried about the general powers. In this, what happened here, can I just put it to you, simple and straightforward? Advocate Mokgoro received a representation relating to a matter which he believed fell within the jurisdiction of the SCCU, which he was the head of.
Yes.
He then took it up with the head of the SCCU in the jurisdiction dealing with that matter and informed you that he was asking questions about it, and we've seen the memo where the questions are asked. You agree with that?
Yes.
He then, after having received the answers and looked at it, decided he was going to do nothing further. I think you intimated in your evidence, you heard later that he decided he wouldn't respond to he wouldn't agree with the representations.
Okay, at the time I was a prosecutor. As I was going through his memo, that wherein I was copied,
Yes.
when meticulously going through the memo, I got a sense that the way it was interrogating, that it was more in favor of the defense than the prosecution. So we started giving me some discomfort. Then I realized at that point that ex facie, it would appear that even decision-wise, whether or not this representation should succeed, possibility looms large that we will disagree with my colleague.
But just, you still haven't answered the question. That you knew that he had taken a decision not to intervene following upon the representation. Or you
Yes.
found out, you gave evidence that you found out, I don't know exactly when, but
the prosecutor in the matter had motivated why
Yes.
those representations could not stand on the basis and,
And-
strength
and
of
he
which
accepted
he
it.
agreed. Yes, yes,
Okay,
I
now let's
agree.
get to where I'm trying to go. Only if Advocate Mokgoro had wanted to uphold the representations and try and stop the prosecution, would the situation have arisen that you speak about. Then he would have had to consult you and you would have had to reach agreement as to whether or not the prosecution goes ahead. But we never got to that position. That situation never arose. So I don't know what the difficulty is in him just getting information.
You know, as I read what Vili said at the meeting, quoting from the NPA Act, the appropriate section, the section does not.
24(3).
The section does not provide, does not give a condition that should the special director uphold, then must consult. The section, if one follows its literal grammatical meaning, seems to suggest that the special director and in concurrent with, in consultation, I think the word
Yes,
used
it
is
is
called
in
in
consultation.
consultation with.
Okay, so he must, if he was going to recommend that there should be a stopping of this prosecution, such decision to stop the prosecution would have had to have been taken in consultation with you. But I agree with you. You agree with that statement?
The way I interpreted at the time, I transcribed it as meaning, as soon as he gets the representation, the tone of the letter will be to the effect that, look, Mhlegas, I've received these representations, as the Act stipulates that whatever I do, I must do it in consultation with you.
So even if he's
This is the process to set in motion
Sorry,
that consultation. Instead, if you cast a glance at the internal memo, it's copied mainly to the acting regional head, my subordinate, and then I'm copied in.
I would consider that in consultation in any case, but that's not the issue. Is your case that even when he's thinking about whether or not there should be any prosecution, he must do that thinking with you, otherwise it's not in consultation? Is that what you're trying to say to me?
It's not what I'm trying to say, it's what I interpreted the law to be saying, that it must be in consultation. It's not Mlochwa's theory.
At this
in that
stage,
regard.
we
That was
will-
my understanding.
Okay, at this stage, we'll agree to disagree, and I'll argue that further. We have no further questions to this witness. Thank you, ma'am.
Thank you very much, Mr. Rip. Ms. Bauer?
I know it's on lunchtime, but I'm going to be very quick and then the witness could be excused. Would that be okay for us to continue?
It would help us all, thank
Yeah.
you.
Advocate Mlochwa, the proposition was put to you that it was not unusual for one prosecutor in one jurisdiction to perform functions in another jurisdiction. In your experience, how common was it for a DPP of one jurisdiction to exercise powers in the jurisdiction of another DPP?
That is what I said in my evidence, that there were rumblings in the NPA that it was not palatable at all.
Let me be very clear. Are you aware of that happening in any other instance?
It was happening for the first time, that if there's a prosecutor from another division, then the head of another division will be appointed to head the project in another division of another. As you can see, the conflict that was arising there, if you look at the emails.
The other question, well, so to answer my question, it was unusual.
I considered it unprecedented.
It was put to you that, and I presume this is Advocate Chiba's view, that it was put to you that if investigators from IPID approached the NDPP of concerns of an investigation, then the NTPP would do something about it. Understood that was the proposition that was put to you. Was there any inquiry made to you as the head of the DPP about it? Here you come, the watchdog of the police comes to the boss of the NPA and says, your DPP promised us prosecutors and he didn't give it to us.
In fact, as I indicated in my evidence, those are the things I heard in these proceedings first time today, that there were meetings with the minister, that there were meetings with the IPAD, At no point were those activities ever brought to my attention at the time.
Now, you were taken to the point of being asked about Advocate Jiba's professional conduct, and then you were stopped short at one example, and you then tended that you had other examples, and I'm going to invite you to provide those other examples to which was alluded to in your cross-examination.
No, as I indicated in my evidence, is that it's like in a family, you'll always have different views. I stated my embedded concern that I would house regarding the issue relating to governance. Can I not proceed any further?
Should I understand that you are not inclined to want to share any further examples with the inquiry?
Can I be given leave to do so, not to?
There is no misunderstanding that when you get summoned to the office of the NDPP, you get summoned to the office of the boss. Would
That
that
is-
be correct?
Yes.
Thank you. I've got no further questions.
Are you?
Mr. Mlotra, I have a question for you relating to the indictment and prosecutorial independence. Has it ever happened that one would get an indictment to just simply sign? And if not, what is the expectation of, what is expected of a prosecutor before they sign an indictment?
You know, as a prosecutor at the time, when you receive the docket, as you go through the docket, some call it fact analysis. You go through the facts, you identify the type of evidence that you have, you identify the perpetrators, you have the evidence, you have your decision, how many you are prosecuting, and then some were different, some are traditional, some are modern. They are against these new modern offenses. They want to go with the traditional ones. And then the second step will be that of drafting either the indictment or the charge sheet. In the KwaZulu-Natal DPP's position, the practice that I found there was that the file that get retained in the office of the DPP will have, if you close the file like this, if you open it like this, it will have 1, 2, and 3 sections. The copies of the docket, if the decision is to prosecute in the regional court, the original will go there. Whatever correspondence the prosecutors will stay in the making, and then the last part will be the part one will call maybe a memo or a report explaining why is that the position. That was the position, the way I understood it then. In the event that prosecutor decides to leave this world, if he dies, if another prosecutor steps in, it's easy because that prosecutor will just go to the last part of the file, look at the memo, oh, 3 accused here involved, direct evidence, fingerprints, and so on and so forth. Hence, the charges, murder, robbery, and so forth and so on. You will notice in my email, I think the same email dated 13 June 2012, the last line wherein I state that I still need to know what I'm signing on. Favor me with the report/memo. It's something, legally speaking, even a law student I think will know that you don't sign something that you do not have peculiar knowledge of.
Just one follow-up question. You were in charge of the KZN office. This is more of your personal manner of how you would deal with things. In circumstances which you find yourself with Advocate Chauke, in those circumstances, if something of a similar nature happened with your subordinates within your office, where one was seeking the other, say, prosecutor to sign an indictment without the accompanying memo or sufficient information. What steps would you have taken if you had been copied in that kind of email?
Without a memo.
Yes.
Look, the issue of disagreement, legally speaking, it's something not unheard of. Because as jurists, as we are all sitting here, we'll all have our own personal views. The practice of compiling a memo or a report in the event with your supervisor, assuming in the case at an DPP office, the senior advocate or the advocate is making a decision, that decision will have to be checked by a deputy or a DPP. In the event there is disagreement between that subordinate making a decision with the supervisor to authenticate, to sign the indictment, that must also reflect in the office note, so that whoever takes the file to court, in the event it's not the two who would have been involved in the handling of the matter, has got a helicopter view that, look, from the word go, there is disagreement here between the person who signed the indictment as well as, because in the analysis of the facts, the application of the law to the facts, some may have a variety of conclusion which will be necessary to be captured in the report.
To be more specific, how did you feel about circumstances where Ms. Jiba was copied in the email with the exchanges between you and Chauke, in as far as him expecting you to sign an indictment when you had requested further information to enable you to satisfy yourself before signing that indictment? How did you feel about a manager who's copied not actually intervening? You had alluded to the fact that you felt like you were swimming against the sea at a certain point.
At that point,
Yeah.
I must be honest, I felt depressed. Felt depressed because firstly, all three of us were consensus at the time that these two will be inextricably linked, the indictment as well as the report. Now I'm getting the indictment without a report. She is favored in the report. There is no response. Advocate Chauke start probing me. Those questions you see about the report, what report, there is no response. Me responding in that email, you can see that I was taking him head on, no response. Copying in not only her, other senior officials in the NPA, nobody picks up a phone and say, guys, what the heck is going on? Can we sit across the table? Let's find things out. That never happened. On that score, I felt disappointed a bit. That's why I felt like somebody was being let down by the system.
And with regard to the delegations, did you by yourself require prosecutors from outside of your jurisdiction to come in and deal with the particular prosecution? Or were you asked to sign the delegations?
I was asked to sign the delegation stemming from the telephonic conversation we would have had that there is a matter that has to be enrolled, with the email from Chauke saying, I'm told you agreed that prosecutors will be sent to your division.
For all intents and purposes, in fact, actually, the delegations were not initiated by you.
No, they were not.
With regard to the examples, the other examples, with regard to questions of governance as they relate to Ms. Jiba, you don't want to take the inquiry into your confidence and give us examples? Or if you insist on not giving examples, do you have, what's your specific reason for not wanting to give examples? Other examples?
No, as I indicated, I've never had a problem with her. She's a big sister. I have my strong views, something that will also have will happen in the family where a brother and a sister will also have views against and for each other.
Yeah, so it's normal to differ. Nothing unusual.
So I wasn't
But if
comfortable.
you're not comfortable.
I wasn't comfortable, for instance, with the handling of this matter. You can see, to me, these are pure governance issues. There are meetings that are being held I do not know anything about. I'm in charge of the division. At no point one is taking me into confidence and say, look, this is what is happening. A colleague of mine is making serious allegations against me and my office. If one looks no action is taken, you can see the colleague is at liberty to say whatever he want to say to me. Nobody comes to my rescue. It's against that background that I thought, and again, there are things that are being suggested here. I pleaded for help. He who alleges must prove no minutes of that. There is no indication in what form was it. Was it written? Was it typed? Was it verbal? That approach. Those are the things that gave me a sense of discomfort, culminating me to, galvanizing me to reach a conclusion that those activities do not sit handsomely and comfortably on the pillars of governance in an entity of NPA's nature.
Thank you.
Thank you so much.
One follow-up question. So,
Just one question. It's a general one.
Yes.
Have you ever received any correspondence directly from Ms. Jiba? Whether it's an instruction or just, do you actually remember a point at which you would receive any correspondence just directly from her?
In recognition of the fact that she was my supervisor, I used to receive quite a lot. For instance, there was an instance where my colleague, Boot Lawrence, went with Mozing, went to KZN regarding the Amigos case. They met, I think there was a guy, Inspector Duploy, who was the IO in the Amigos case, as well as the auditors, represented by Trevor White, if I'm not mistaken. I was not at that meeting, but it seems there was an exchange of words, that's what I had, between my colleague Mkhwebi with Duploy. When Duploy, Mkhwebi was asking questions about the case, got a sense that Mkhwebi wanted to withdraw the case, where he confronted him saying, why don't you talk straight and tell us that you are here to withdraw the case? So in that instance, the following day, I think I was on my way to Lady Smith, it was making headlines in the Mercury that there was interference by the special director from the head office. I think I received a call from her late in the afternoon saying, hey, Simpiwe, did you see this article? Please immediately consult or contact Mthunzi Maga at the time, because there are questions from the media. So I used to receive quite a number of, even the SMSs. Sometimes we will exchange SMSs. As I say, our relationship was not a sour relationship, just that when it comes to professionalization of the relationship, there will be those things that will give me, at a personal level, I don't know what other people's were feeling.
thank you, Mr. Mlocho.
Thank you so much.
Sorry, Jack, can there be follow-up questions arising from what you've just asked?
Follow-up cross-examination. Okay, you may do so.
Yes, thank you. The questions you were asked by Ms. Vilagazi relating to the fact that you felt like you're swimming against the tide relates to the fact that you feel that Advocate Jiba could have intervened in your communication with Chauke because she was copied onto the letters. Am I correct?
As I indicated, I've got quite a number of examples that I can make, including the emails.
No, I've just picked up that one.
To substantiate that one.
I've
If you're
picked up-
interested, I will do so.
No, I picked up that one because that's the one you testified on.
Come again, what is the question?
Okay, that helps. So you were asked by Ms. Vilagazi about your feeling relating to the fact that Advocate Jiba was copied on your communication with Advocate Chauke, and you
Yes.
said you felt like you're swimming against the tide.
Yes.
Right. Can I ask you this? When Advocate Chauke responded to your email and apologized, you said in your testimony that you felt that because he had apologized, that was okay.
Yes.
Why would Advocate Jiba get involved? Why do you think Advocate Jiba should have been involved after you had received a response to your email from Advocate Chauke apologizing
Okay.
and calling you brother?
Yes. I will go back to my explanation. KZN is the province, at the time, I think, with a population between 11 and 12 million rand. I had quite a number of cases I was dealing with in the province. But because today I was confined to a single case, there were other cases as my line manager would have dealt with her.
Okay, so is there a process in the NPA of raising a complaint against a colleague, a formal complaint against a colleague, for the specific attention of your manager so that your manager intervenes? Is there a process that must be followed to deal with those kind of problems where there is a breach, a break in relationship between you and your other colleagues?
If you may bear with me. If I say I was swimming against the tide, there was a time.
Sorry, you have to respond to the question that I asked. You're now talking about swimming against the tide. I asked you if there is a policy within the NPA that governs how you register grievances against persons that you have grievances against. Now,
Yes.
I didn't ask you about swimming against the tide.
Yes, but it would go back to swimming against the tide, my answer. The process is, when I was about to step down in the Mail and Guardian, there was a guy called Nick Dawes. I'm not sure if I'm correctly pronouncing his surname, from the Mail and Guardian. Somebody told him that my days in the KZN were numbered as the DPP. And then Nick Dawes was sent the questions to my colleague Advocate Mokgoro. In that email, in the Mail and Guardian, you can get I think it will be the Mail and Guardian between 2 July and 9 July. Advocate Mokgoro said, why do you approach me for answers? Because your source is Advocate Mlojwa. I felt gravely aggrieved by that statement. I lodged a grievance with the NPA, nothing turned on it. That's the procedure I was trying to follow. And then with that, at some point, there was an allegation I was overpaid with the salary. That was investigated. Eventually, it was discovered that I was never overpaid. There were other incidents that were happening other than what I'm talking about here. Hence, I said to you, if you want me to continue with the examples, I will be giving you the examples relating to the procedure.
No, Mr. Mlojo, it is not the question that I asked. The question I asked was really about the existence of a policy, of a grievance policy that one could follow. I mean, the answer could be yes, there is, in fact, a grievance policy that is followed. If I needed to know whether you had utilized that grievance policy in relation to the issues that you testified on, I would ask you that question. That's really what I wanted to ask. I mean,
Thank you.
it was arising from what Ms. Vilagazi had asked you. So I wasn't inviting you to give me examples. I was only asking you to give me knowledge of whether or not there is a process that is followed.
I apologize. I interpreted the question as an open question, not a closed question.
No, it was a closed question, actually.
Thank you so much. Yeah.
The final question really is this one. You say that a colleague of yours was making very serious allegations against you, and you felt that nothing was being done. It really relates to whether or not you activated your grievance procedure in accordance with the policy of the NPA. Did you do that?
No.
Okay. Now, I want to put it to you this way. The part of what Ms. Villaga asked you was about prosecutorial independence. It is not desirable, and I put it as a proposition, you can differ with me or not. It is not desirable that at every squabble between prosecutors, the NDPP copied on them and that she should intervene. It's not desirable because we are expected to stand your ground, which is what you did here against Advocate Chauke. And you stabilize your professional relationship with him without the intervention of anybody else.
Not only him, with all the officials.
Yes, that's what I'm glad you put it broader than that. But so you're expected to stand your ground, and if there is a collapse of a process or a violation of the NPA process, you're expected to report that through the normal process of reporting, right?
I wouldn't agree with you on that one.
Okay.
As I said to you, NPA has got values, among other things, issue of transparency. And if you look at it, transparency in its primordial form, it will suggest that sunshine is the greatest disinfectant, in the sense that when I had problems with the Advocate Chauke, it was all in the open, coping in the senior officials. It was all out there.
Yes.
As far as I'm concerned, that was in full compliance with one of the values of transparency that are in the NPA policy.
I understand that. I think you make sense with that. I mean, I know that that's how you see it. But one way of ensuring that your professional lines remain firmed up is being able to, when you see a colleague going outside an NPA process, to go to that colleague and to say, no, this is not how we do things here. This is how we should operate around this. Am I correct? That's just one way of doing it.
Agree
You don't
with
always
me.
have to lodge a grievance.
You agree with me? The same I did in the email when I was telling Chauke, do you know the constitution? Do you know this? Do you know that?
Yes.
Going forward, let's respect each other, no principal-pupil relationship. As long as I get the report as we agreed, I'm prepared to work with you as a brother and a colleague.
Yes. And then, of course, that resulted in you and him, as they put it, kissing up and making up. Not literally, but... okay.
You know, I'm a firm believer, you know, we have to listen
forgiveness, yes.
to Peter Tosh, mystic man of the past, living the present, marching into the future.
Yeah, man. Hear you. Okay,
I was going to
finally.
say, yeah, man. Thank you so much.
Just
Oh, that's- you've not
finally.
done it? Oh, yeah,
No,
man.
I mean, it's really maybe just a closing remark. Of course, you did philosophy, so most of what your approach to things do come across like we're going to read some books from you, and we look forward to that.
Thank you so much, my brother. Hope to do the case, though when you said you put it to me, I had a problem in court one day when the lawyer said, I put it to you, and the witness said, put it wherever you want. I'm telling you, this is the truth.
Okay. Okay, thank you so much, Mr. Mlocho.
Thank you so much, Chairperson.
Thanks for your willingness to assist, okay,
Thanks.
and for taking the time. We appreciate it. You may stand up. Can we passed our bedtime now, ne? But can we stand down adjourn rather, until, we can still make it 2 o'clock? Yes, it will work. Until 2 o'clock, we.